Assalamualaikum warahmatullahi wabarakatuh and a very good evening. I bid to our respective lecturer. Before we start our presentation, here is our scenarios. Tan Sri Baru, Datuk Sri Buruk and Datuk Baba are members of parliament who won their seat during the recent general election. Tan Sri Baru is a minister in the cabinet in charge of legal affairs. He criticized the president of his party, who is the current prime minister, for not being brave enough to combat corruption among members of the party. In a special meeting of the party later, it was decided that Tan Sri Baru was stripped of his membership and was no longer a member of the party. The Prime Minister also announced that Tan Sri Baru has been removed from the cabinet and no longer holds the position of minister. Tan Sri Baru claims that the decision is unfair and arbitrary because he was not allowed to defend himself. Furthermore, he believes that the Prime Minister, who is also the president of the party, must respect his right to free speech and to criticize the party leadership. Datuk Sri Buruk, a member of an opposition party, has been expelled from his party. He then forms a new party and becomes the president of the party. Datuk Baba, an independent member of parliament, pledges support to the current Prime Minister. The Speaker of Dewan Rakyat then declares that Tan Sri Baru and Datuk Sri Buruk cease to be members of that house and their seat shall become vacant because they have changed party after being elected as MPs. Tan Sri Baru and Datuk Sri Buruk object to the declaration made by the speaker and argue that their rights to be members of political party have been deprived. Tan Sri Baru and Datuk Sri Buruk demanded that the speaker declare the seat of Datuk Baba vacant because he should also cease to be a member of parliament. However, the speaker refuses to do so. Then Tan Sri Baru and Datuk Sri Buruk bring legal action against the speaker in the court to compel the speaker to declare that Datuk Baba has ceased to be a member of parliament. So with that, let's move on to the first issue. Alright, so let's address the first issue in our present case concerning on whether the expulsion of Tan Sri Baru from his political party and cabinet post following his criticism of the Prime Minister violated his constitutional right to freedom of speech under Article 10, Clause 1, Clause A and the principle of natural justice. To begin with, by referring to Article 10, Clause 1, Clause A of Federal Constitution, it guarantees every citizen the right to freedom of speech and expression. This includes political opinions, written or oral statements, and public criticism, especially within a democratic setting. However, under Article 10, Clause 2, Clause 8, Parliament may impose restrictions on the right only if it's necessary in the interest of national security, public order, or morality. This sets the scope for legitimate limitation. In the case of public prosecutor against OAK side, Raja Azlan Shah Court Chief Justice emphasized that freedom of speech cannot be absolute or uncontrolled, as unregulated liberty may lead to anarchy. This constitution seeks to balance individual liberty with public interest. To apply in our present case, Tan Sri Baru's criticism of the Prime Minister focused on issues of internal party accountability and corruption. It did not incite violence, it did not threaten national security, and it did not breach morality or public order. Therefore, his expression clearly falls within the protection of Article 10, Clause 1, Clause A, and there is no legal basis under Article 10, Clause 2, Clause A to restrict it. This position is strongly supported by several leading cases. First, in Madhavan Nai v. Public Prosecutor, the court ruled that any limitation on free speech must fall strictly within Articles 10 Clause 2, 10 Clause 3, or 10 Clause 4, otherwise it is invalid. In addition, in the case of Sivarasa Rasyah v. Badan Peguam Malaysia, the federal court held that restriction must be both reasonable and proportionate. And in the case of public prosecutor V. Param Kumarasamy, political criticism of public institution was held not to be seditious unless it incite disloyalty or hostility. In our present case, Tan Sri Baru's remarks do not fall within this exception. They were constructive and political in nature, and thus it is constitutionally protected. In addition to the constitutional right to speech, we must also consider the principle of natural justice, particularly the role of audi alteram partem, meaning that the right to be heard. In both Lee Kwang Wah v. Public Prosecutor and Zainul Zakaria v. Public Prosecutor, the federal court affirmed that procedural fairness is fundamental, even if when no explicit stated in law. Here, Tan Sri Baru was expelled from the party without being given a chance to respond to the allegation. This constitutes a clear violation of natural justice, especially considering the gravity of the consequences, which is his public disgrace, loss of party standing, and the loss of cabinet position. Now, turning briefly to his cabinet removal. Under Article 43, Clause 5, the Prime Minister may advise the Yang di-Pertuan Agong to dismiss a minister at his pleasure. So, yes, legally the Prime Minister's action is valid, but the context matters if that removal was made in retaliation for protected political speech. Then, while legally permitted, it raises serious constitutional concerns about the misuse of the executive discretion. To conclude, Tan Sri Baru's removal from the cabinet may be technically valid under Article 43, Clause 5. However, his expulsion from the party, particularly without a fair hearing, constitute a serious violation of both Article 10, Clause 1, Clause A, freedom of speech, and the second one is the principle of natural justice. To emphasize, his criticism was legitimate political expression, not sedition or public disorder. As such, the disciplinary action against him was disproportionate, procedurally flawed, and constitutionally indefensible.
Moving on to the second issue, where the question is whether the Speaker announcement that Tan Sri Baru and Datuk Seri Borok have vacated their parliamentary seats is valid under Article 49A of the Federal Constitution. This requires us to examine the legal requirements under Article 49A, whether those requirements were followed and whether the courts have the authority to review the Speaker action. Article 49A Clause 1 states that a member of parliament loses their seat if they resign from or cease to be a member of their political party. However, 49A Clause 2B provides an important exception. If the MP is expelled, they do not lose their seat. Article 49A Clause 3 further states that the Speaker may only act upon receiving written notice of the vacancy from a fellow MP. This limits the Speaker's power and enforces procedural compliance. Although Article 63 Clause 1 grants some parliamentary privilege, it does not shield unconstitutional conduct. In the federal court case of Ting Tiong Chun, it was held that the courts may review the Speaker's decision to ensure compliance with the Constitution and natural justice. Applying this to our case, the Speaker declaration is only valid if two conditions are met. First, the MPs must have resigned voluntarily, not been expelled. Second, the Speaker must have acted only after receiving a valid written notice. If either of these steps is missing or incorrectly interpreted, such as treating an expulsion as a resignation, then the declaration is unconstitutional. The Ting Tiong Chun case reinforced this point, where the court ruled that any failure to comply with constitutional safeguards render the Speaker's action subject to judicial review. Beyond legality, the Speaker's declaration raises important human rights concerns. First, under Article 10, Clause 1C, all citizens have the right to freedom of association, including the right to join political parties. Misclassifying an expulsion as a resignation undermines this freedom. Second, Article 5, Clause 1 ensures personal liberty, which the courts have interpreted to include the right to fair process. Third, Article 8 Clause 1 guarantees equality before the law. Bias or inconsistent application of rules can lead to discriminatory treatment. Lastly, voters also suffer when MPs are removed arbitrarily. The electorate is denied their democratic voice. To conclude, the Speaker's declaration is only lawful if both constitutional conditions are met, whereby that the MPs resign voluntarily and that proper written notice was received. If either this condition is missing, the declaration is unconstitutional and subject to judicial review. As the Federal Court stated in Ting Tiong Chun, even the Speaker must act within the limits of the Constitution. Protecting procedural fairness is not just a technicality, it is essential to uphold the rights of MPs and the will of the people in a democratic society.
Now I will move on to the next issue, which is whether the Speaker's refusal to declare Datuk Baba's seat vacant, despite his political alignment with the ruling party, constitutes unequal treatment and a breach of Article 8, Clause 1 of the Federal Constitution. Under Article 8, Clause 1 of the Federal Constitution, all persons are guaranteed equality before the law and equal protection of the law. This provision requires public authorities, including the Speaker, to treat similar cases in a consistent and non-discriminatory manner. The Federal Court in Beatrice Fernandez v. Sistem Penerbangan Malaysia clarified that Article 8 applies to public authorities and that your action must be free from arbitrariness and discriminatory intent. In a way, any differential treatment must be justified on rational and objective ground to make it valid. In Dana Harta Urus Sdn Bhd v Kekatong Sdn Bhd, the court held that the differential treatment is only valid if it based on rational and objective ground, not political motivation. This is supported by the doctrine of rational classification, which has two conditions. First, there must be an intelligible differential between those treated differently. Second, that differential must be rationally connected to the administrative objective. In our present case, all three MPs changes their political stance. The speaker treated Datuk Baba differently solely because he was initially independent, but this difference is not intelligible nor legally relevant. Therefore, the classification fails both limbs of the rational classification test. So now let's consider the facts. The speakers vacated the seats of Tan Sri Baru and Datuk Sri Buruk, citing their post-election change in political allegiance. But no action was taken against Datuk Baba, who was elected as an independent MP but later aligned himself with the ruling party. In substance, all three MPs realigned politically after the election, yet only two were penalized. This raises a strong presumption of unequal treatment and potential abuse of discretion by the speaker. In Public Prosecutor v. Su Liang Yu, the court ruled that the core idea of equality is equal justice. Everyone must be equally subject to the law. Similarly, in Public Prosecutor v. Kong Teng Keng, it was held that the law must operate alike on person in a similar situation. Here, the speaker's failure to comply the same standard to all three MPs contradict this ruling, undermining both legal consistency and public confidence in institutional fairness. The Speaker's decision is not part of parliamentary debate. It is an administrative decision and therefore subject to judicial review. As established in Lee Kuan Yew v. Public Prosecutor, courts may review and set aside arbitrary decision by public authorities. Likewise, in Muhammad Faizal Musa v. Menteri Dalam Negeri, the Court of Appeal struck down executive discretion that was unreasonable, disproportionate, and lack of logical justification. The Speaker's selective enforcement in this case fits squarely within those grounds. In conclusion, the Speaker's refusal to declare Datuk Baba's seat vacant while taking action against Tan Sri Baru and Datuk Sri Buruk reflects unequal treatment under Article 8, Clause 1 of Federal Constitution. The rational classification task fails. The Speaker's action is arbitrary, politically biased, and constitutionally suspect. As such, Tan Sri Baru and Datuk Sri Buruk have strong legal grounds to challenge the decision through judicial review.
The final issue concerns whether the Speaker's decision to declare a parliamentary seat vacant can be challenged in court. This question touches on the tension between the Speaker's discretion and the constitutional principle of judicial oversight. Specifically, we must examine whether such a decision is protected by parliamentary privilege or whether it can be subjected to judicial review when a constitutional rights are at stake. On to the rules, Article 4, Clause 1 of the Federal Constitution declares that the Constitution is the supreme law of the Federation. This means that all authorities, including the Speaker of Parliament, must act within constitutional limits. Although Article 63, Clause 1 protects parliamentary proceedings from court interference, this immunity is not absolute. The case of the Speaker of Dun Sarawak and Ting Tiong Chun 2020 confirms that courts can intervene when constitutional limits are breached or natural justice is denied. The High Court in Ronald Kendi and Johari Abdul 2023, however, emphasized that judicial review only applies if the Speaker's decision exceeds the scope of Article 49A or is unconstitutional. To apply in this case, judicial review becomes necessary when the Speaker exceeds constitutional boundaries or fails to uphold natural justice, such as denying an MP the right to be heard before declaring their seat vacant. This principle was clearly demonstrated in the Ting Tiong Chun case. There, the Federal Court held that the disqualification of an elected representative without a fair hearing was unconstitutional. The Court intervened to protect the MP's right to due process and affirmed the importance of equality under Article 8, Clause 1 of the Federal Constitution. On the other hand, the High Court in Ronald Kendi upheld the Speaker's decision not to declare 4 parliamentary seats vacant. The Court found that the Speaker had acted within the scope of Article 49A and followed proper procedures. As a result, judicial review was not permitted. This illustrates that judicial review is not automatic. It only applies when constitutional safeguards are violated. Beyond constitutional claims, this issue also involves fundamental human rights. Elected MPs have the right to be heard before any decision affecting their position is made. This is part of the broader principle of natural justice. Under Article 8, Clause 1, all individuals are equal before the law. If the Speaker's decisions are applied arbitrarily, inconsistently, or with political bias, they violate this right. In Ting Tiong Chun, the MP was treated differently from others without justification. This unequal treatment was a clear breach of constitutional right. In addition, there are implications for democratic representation. Arbitrary removal of MPs deny voters their chosen representative. This undermines public trust in the electoral system and weakens the foundation of parliamentary democracy. Judicial review therefore acts as a critical safeguard. It ensures that decisions by the Speaker are legally justified, procedurally fair, and free from political interference. It protects not only the rights of MPs, but the democratic voice of the electorate. In conclusion, the Speaker's decision can be challenged through judicial review when it violates constitutional safeguards, breaches natural justice, or results in unequal treatment. Ting Tiong Chun and Ronald Kendi illustrate the limits of parliamentary privilege and affirm the judiciary duty to defend constitutional rights. Judicial review ensures that the Speaker's power is exercised lawfully and that both MPs and voters are protected from unjust or politically driven decisions.